Thousands of American savings and loan institutions became insolvent in the savings and loan crisis of the 1980s. Some of those institutions attempted to avoid government takeover with questionable or illegal practices. The case of American Continental Corporation, Lincoln Savings and Loan Securities Litigation, Jones Day, explains how one major law firm ventured into ethically murky waters when advising a savings and loan during this crisis. American Continental Corporation, which owned Lincoln Savings and Loan, hired law firm Jones Day, Reavis, and Pogue to audit Lincoln's compliance with Federal Home Loan Bank Board regulations. Two Jones Day partners, including William Schilling, led the audit. Before joining Jones Day, Schilling had worked for the Federal Home Loan Bank Board and had noted that Lincoln committed numerous and severe regulatory violations. During Jones Day's audit of Lincoln, Schilling again found multiple violations. Schilling and Jones Day then instructed American Continental and Lincoln about how to correct the violations in a way in which federal regulators wouldn't uncover their remedial efforts. Jones Day also acquiesced to Lincoln's destruction of documents and knew that Lincoln had committed fraudulent activities and didn't make the corrections that Jones Day had advised. In addition, Jones Day wrote a favorable opinion letter and an American Continental bond registration statement. Regulators eventually discovered these activities. As a result, the federal government and several American Continental investors brought securities fraud and other claims against Jones Day in federal district court. The government and investors alleged that Jones Day breached its fiduciary duty to Lincoln and helped American Continental and Lincoln hide regulatory violations. Jones Day moved for summary judgment, arguing that it couldn't be held liable for representing its client and maintaining client confidentiality.